Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm here today with Martin Brazier, who's one of our senior data protection consultants here at URM. Welcome to another episode of InfoSec Insider, Talk DP. So today, Martin and I are going to be talking about sharing personal data with the police. So we're looking at that in terms of occasions where you might need to report a crime to the police, or the police may approach you asking for personal data to help them with their inquiries. So Martin and I are going to be looking at how you can do that while remaining compliant with data protection law. So Martin, my first question for you is, what is the background to dealing with requests for personal data from the police?
Well, I think a good place to start would be to look at the legislation which governs the police's use of personal data. This originally came from an EU directive in 2016, before we left the EU, which applied to us as an EU member. And the UK enacted it as Part 3 of the Data Protection Act 2018, and that covers personal data processing for law enforcement purposes by what are known as competent authorities. These authorities are listed in a schedule to the Data Protection Act and include all the chief constables of UK police forces, any UK ministerial government departments and so on. And the Data Protection Act also defines law enforcement purposes as the prevention, investigation, detection or prosecution of criminal offences, or the execution of criminal penalties, including safeguarding against and prevention of threats to public security. However, if you're not a competent authority, that doesn't apply to you, and the normal GDPR and Data Protection Act would apply to you. There may be circumstances where you need to proactively share personal data to report a crime to the police, and to provide relevant personal data in relation to reporting that crime. And you may also receive a request from the police for personal data you hold to help them investigate a crime. And these requests often come from the police on a standard form, which normally provides you with enough information to consider whether to share that data. You may also receive a court order or other legal obligation which compels you to share data with the police.
So does data protection legislation compel you to share personal data with the police?
In short, it doesn't, no. However, it does provide you with a framework to permit you to share information with the police for law enforcement purposes where it's necessary and proportionate to do so. The framework also permits you to share data in response to a court order or other legal requirements. Often it will be obvious that you need to share personal data, but at other times you need to think very carefully before you commit to sharing. If you receive a court order for information, you must provide it, as not complying with a court order can represent a contempt of court.
Perfect. Thanks, Martin. So what aspects do organisations need to consider?
Well, the first consideration will be the lawful basis for sharing the information in accordance with the lawfulness, fairness and transparency principle. You'll need to consider which, if any, of the 6 lawful bases in Article 6 of UK GDPR will apply. One lawful basis which might apply is that of legitimate interests under Article 6.1f, where processing is necessary for your legitimate interest or those of a third party, such as the police, provided those interests are not outweighed by the interests, rights and freedoms of the individual whose data you're sharing. So, for example, your legitimate interest might be to report a crime or to share personal data of an individual suspected of a crime with the police to make sure that there's a fair and proper investigation. If you do receive a court order or have a statutory duty to report potential crimes to the police, then your lawful basis is likely to be legal obligation, which gives you a lawful basis to share personal data where it's necessary for you to comply with a legal obligation. It's rare that the lawful basis of consent presents a practical approach in these cases. Consent can be withdrawn, and consent must be able to be withdrawn easily. So it's only really appropriate if the individual has a real choice in agreeing to you sharing their personal data. Whilst a victim of crime might be willing for you to share their personal data, an alleged perpetrator is unlikely to do so. And so for these reasons, consent is unlikely to be your first choice for consideration. If the organisation exercises an official authority, it may be possible to rely on public task as the lawful basis. However, you need to be able to demonstrate that sharing personal data is necessary to exercise your specific official authority and identify a clear basis in law. There may be times when you're processing personal data for the purposes of crime prevention and detection, such as if you have a CCTV system. In this case, you need to be clear on the privacy policy about the purpose that the CCTV images may be shared with the authorities.
And what else do organisations need to consider?
Well, you should also consider whether the sharing represents further processing in a manner which isn't compatible with the original purpose for holding the data. This is covered by the purpose limitation principle, which says that personal data should be collected for specific, explicit and legitimate purposes and not further processed in a manner which is incompatible with those original purposes. You can normally only process personal data for a new purpose, which you didn't originally anticipate, if the new purpose is compatible with the original purpose. If you get the individual's specific consent for the new purpose, or if you can point to a clear legal provision requiring or allowing the new processing in the public interest, you'd be okay. If the new purpose is compatible, for example, if you were processing information from CCTV, which was installed to prevent and detect crime, then you may not need a new lawful basis to further process the data. This situation is different if you originally relied on consent, as you will need to get fresh consent, which specifically covers the new purpose. And we've already covered the difficulties in relying on consent as a lawful basis. However, you can consider the crime and taxation exemption in Schedule 2 of the Data Protection Act. This exemption applies if you process personal data for the purposes of the prevention and detection of crime or the apprehension or prosecution of offenders. It exempts you from some of the UK GDPR's provisions, including the purpose limitation principle, meaning that you don't need to consider whether sharing personal data with a law enforcement authority is compatible with the original purpose. You must still comply with the requirement for the processing to be lawful, which means you still need a lawful basis. And in practice, this is likely to be your original lawful basis for processing the personal data, unless you originally relied on consent. But depending on the circumstances, a new lawful basis might be needed, such as legitimate interests. You also need to think about the data minimization principle, so that you only provide as much personal data as is adequate, relevant and necessary for the purpose of sharing with the police. How much personal data is necessary isn't defined in the legislation, and you'll need to determine this depending on the circumstances. The balance is that the personal data is necessary for the police to fulfill its law enforcement purposes, but no more. It may be that the police will tell you what data it needs and why it needs the personal data you hold. And if you receive a court order to disclose personal data, this will tell you exactly what you must provide and why.
What about if the personal data includes special category data?
Well, special category data is personal data concerning an individual's racial or ethnic origin, political opinions, health, religious or philosophical beliefs, trade union membership, sexual orientation, sex life, genetic and biometric data, and so on. It doesn't include personal data about criminal offences, allegations or convictions, but we'll cover that in a moment. As well as having a lawful basis under Article 6 to share special category data with the police, you'd also need to identify a specific condition for processing special category data under Article 9. Of the 10 conditions for processing special category data, sharing data for the prevention or detection of crime is covered in Article 9.2g. You would also need a linked condition from paragraph 10 of Schedule 1 of the Data Protection Act, which would be for preventing or detecting unlawful acts. This condition would be enough if the sharing were necessary for the purposes of preventing or detecting crime, where obtaining the individual's consent would prejudice those purposes, and the disclosure is necessary for reasons of substantial public interest, and that could be to prevent and detect crime. In practical terms, substantial public interest is taken to mean what's in the best interests of society. So you've got to be able to maintain that the sharing is required to prevent or investigate a crime, and that it is in the public interest to do so. So when processing personal category data, some of the conditions in Schedule 1 require you to have an appropriate policy document in place. However, this is not the case when relying on the condition in paragraph 10 to share special category data with the police.
What about when the personal data includes criminal offence data?
Well, criminal offence data includes personal data about criminal convictions and offences or related security measures, which would include allegations of an offence. You can only share criminal offence data if you have a lawful basis under Article 6, and either the processing is carried out under the control of official authority, or if you have lawful authority under Article 10. Again, Schedule 1 can provide you with lawful authority, and you can rely on this if the sharing is necessary for the purposes of preventing or detecting a crime, where again asking for the individual's consent would prejudice those purposes, and where the disclosure is necessary for the reasons of substantial public interest. Paragraph 36 of Schedule 1 of the Data Protection Act removes the requirement to explicitly demonstrate that the processing is necessary for the reasons of substantial public interest for criminal offence data. But if the sharing also includes special category data, you'll have to do it anyway. When you rely on the condition in paragraph 10 to share criminal offence data with the police, it's not necessary to have an appropriate policy document in place.
So do organisations need to tell individuals that they're sharing their information with the police?
Well, generally, data protection law provides individuals with a right to be informed, and the first data protection principle provides for transparency. Individuals have a right to be informed about what you do with their personal data, including any data sharing that you do. However, in some cases, informing individuals that they're suspected of a crime can prejudice investigation or allow them to evade detection. The crime and taxation exemption I mentioned will exempt you from the provisions on the right to be informed and the transparency principle, as the exemption applies if complying with these provisions would be likely to prejudice the purposes of processing for crime prevention, for example.
Thank you, Martin. So just to finish us off, do you have any sort of closing thoughts, anything else we need to bear in mind?
Well, when you're sharing data with the police, you need to comply with all the usual obligations you have under data protection legislation, such as processing personal data fairly, ensuring accuracy of the data that you share, and providing appropriate security measures, bearing in mind that the more sensitive personal data requires greater protection. As part of your obligations under the accountability principle, you should document your decision making and keep a good record of the data sharing so that you can demonstrate compliance. When you're considering sharing personal data with the police, you may be mandated to perform a data protection impact assessment if the sharing is likely to result in a high risk. But using the framework of a DPIA to shape your decision making and to record the process is good practice, even if you decide it doesn't represent a high risk.
Amazing. Thank you so much, Martin. And for any of our listeners that want to learn some more about this topic, we've got a great blog on our website, urmconsulting.com, which is called Sharing Personal Data with the Police. So thank you for your time today, Martin, and thank you everyone for listening. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube, and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.